Welcome everyone who has joined and to those who are about to join to this Landmark Chambers Property Nuts and Bolts Part 4 Boundary Disputes webinar. We're delighted to see so many of you joining us today and hope that you're going to find this informative and helpful. So, kicking off, my name, as I've already said, is Tom Morris. I'm a junior barrister at Landmark Chambers. I was called in 2016 and I'm a specialist property litigator. I'm proud to say I've acted on numerous neighbour disputes. I'm presently instructed on more boundary disputes, I think, than I can number. And I was sole counsel in the long-running boundary disputes that ended up in the Court of Appeal at the end of last year called Clapham and Naga, where I acted for the successful appellants. I should say that I passionately enjoy boundary disputes, not because of the horror and distress that they inflict upon those who litigate them, but because the legal issues that they throw up tend to be real property law 1A, and because, as well as being very interesting legally, they allow plenty of scope for creative lawyering. We were going to hear from Kate Traynor this evening, who's another junior at Landmark Chambers, but regrettably she has become unavailable at the last minute. But don't panic, because she has very kindly shared her comprehensive notes with Harley and with me, and we have divvied up her talk between us, and doing the best we can, we will run through the general principles that she was going to cover off. I asked Harley earlier if he could send me his biography, just for the sake of form, really, and I got the most modest 3-bullet point note, which I note doesn't even refer to his doctorate in property law. So what he wants me to say is that his practice encompasses all aspects of the law relating to the use and development of land. He is frequently instructed in boundary disputes, and also that he is a member of the editorial team for the Encyclopedia of Housing Law and Practice. I should also say that Harley is a titan of the junior property bar, an extremely knowledgeable and brilliant advocate, wonderful with clients, and one to instruct on any property dispute. Now, because my talk at the end on the role of surveyors, for reasons which I hope will become clear, is going to be quite short, I'm going to spend a little bit more time now introducing boundary disputes. And I start with this poster that I was delighted to see at the cinema yesterday. And if you peer at this, you will see that such is the horror of the boundary dispute, such a hold do they have on the popular imagination, that someone is actually making a film about neighbour disputes. And my talk later on the role of experts may not be as, quote, ridiculously entertaining, and it may not grab the audience by the jugular like Restless, but I will do my best. And if I fail to do so, you will have to go and see this film when it hits cinemas on the 4th of April. Now, as may be well known to practitioners, the leading authority on the litigation of boundary disputes is William Shakespeare's seminal play, Hamlet. And I say that because when a boundary dispute reached the House of Lords in 1999, that is where Lord Hoffman began his analysis. What he said was, boundary disputes are a particularly painful form of litigation. Feelings run high and disproportionate amounts of money are spent. Claims to small and valueless pieces of land are pressed with the zeal of Fortinbras's army. It is therefore important that the law on boundaries should be as clear as possible. I emphasise the last sentence because that's going to be something that we keep returning to over the course of these talks. Now, Fortinbras was the Prince of Norway, the headstrong warrior who was bent on avenging his father's death at Hamlet's father's sword, who headstrong marched his army to reclaim the lands that his father lost in the duel. And given the weight of Lord Hoffman's pronouncement, it's perhaps unsurprising that there seems to exist a rule in England and Wales today that any judge who is asked to try a boundary dispute must do their utmost to avoid doing so, and to entreat the litigants to see sense and to settle, and to gasp in frustration at how stupidly they have frittered away their savings on getting a case to court. And it is a rare thing, in my experience, for a judge to respect the wishes of both sides, that a boundary dispute be determined by a judge, and for them to understand the importance of the matter to the parties. Instead, judges tend to cite Hamlet over and over again. So here we have a quotation from Lord Justice Briggs, as he then was in Palmer and Upton in the Court of Appeal in 2015. The blood, toil and sweat which has been devoted to this litigation would even have horrified Prince Hamlet, who, watching Fortinbras march away with his army, observed, "While to my shame I see the imminent death of 20,000 men that, for a fantasy and trick of fame, go to their graves like beds. fight for a plot whereon the numbers cannot try the cause, which is not tomb enough and continent to hide the slain. Oh, from this time forth my thoughts be bloody or be nothing worth. And again, another reference to Hamlet from Lord Justice Sedley in Strachey and Ramage, who says, when Lord Hoffman in Allan Whibley and Inslee spoke of litigation conducted with the zeal of Fortinbras's army, he will have had in mind, like Lord Justice Rymer, the little patch of ground that had no profit in it but the name. He went on and complained that in the present case, a poorly drawn conveyance left in doubt the ownership of a patch of ground a fraction of an acre in size. Neither party, so far as one can tell, needed to own it in order to enjoy the use of the rest of their land, though both found its use convenient. Whichever of them held title to it, an easement of use or access should have satisfied the other's needs. But instead of reaching a compromise along these lines, war was declared. Unlike old Caspar after Blenheim, we can now tell who won. But whether the expenditure on law and lawyers, vastly exceeding the value of the piece of land, has been worthwhile, one has to doubt. So there are some clear statements of the attitudes of senior members of the judiciary to boundary disputes. One thing is clear, that neighbouring landowners are not heeding the warnings from the judiciary and the pronouncements from the highest courts in the land. Recently, the Times legal editor, Jonathan Ames, on the 7th of March, published an article entitled "Boundary Disputes Surge as Neighbours Want Day in Court Despite the Costs." He went on to refer to an anecdotal, notable increase in neighbour disputes in the last 12 months. I'm proud to say that one of the examples that he gave was the case of Clapham and Naga, which was the last boundary dispute to make it to the Court of Appeal, and in which, as I may already have mentioned, I acted unled for the successful appellants. He speculated as to the cause. He said the cause of this increase is not obvious. There is no change in legislation or development in the case law. What he suggested was that triggers of boundary disputes might be unclear deeds, differing interpretation of boundaries, encroaching boundary features, and changes over time, all of which we will cover over the course of our talks. There is one wonderful quotation which he didn't refer to, which is attributed by Mr. Justice McGarry to Lord Westbury, who said that deeds may be difficult to read, disgusting to touch, and impossible to understand. And so we who practice in this area continue to find. In fact, the article was taken up even by veteran Times columnist Libby Purves, who devoted her weekly column to the phenomenon of the boundary dispute. And the attitude of all of these journalists reflects that of the judiciary. They, and especially the tabloids, marvel at why it is that people fight boundary disputes all the way to court. I have a theory as to why this is, which is not based simply on the lunacy of litigants or any faded principle that an Englishman's home is his castle. My theory is more simple. The law, as those of you who practice in this area will know, and as our talks will explain, is simply fiendishly complicated. You'll recall what Lord Hoffman said in Inslee: "It is therefore important that the law on boundaries should be as clear as possible." The problem for landowners is that it is not. As contracts go, conveyances are very difficult to interpret, difficult to read, disgusting to touch, and impossible to understand, as Lord Westbury repeatedly said. They are difficult to read, not least because they often turn on findings about features on the land decades, if not centuries ago. And because of that uncertainty, judges and Parliament have found increasingly ingenious ways of achieving certainty. Adverse possession is the most famous parliamentary attempt at quieting titles, and everyone will know how fiendishly complex is the law of adverse possession. And indeed, in Clapham and Naga, in the Court of Appeal, that was all about the interrelationship between adverse possession in unregistered land and the law of land registration. And the Court of Appeal found that both the trial judge and a High Court judge in the Chancery Division had misunderstood the law. So that only goes to show how complex it is. Judges, for their part, have also been busy trying to find ways of aligning legal boundaries with the reality of the use of land on the ground. It is to judges that we owe the principles of boundary agreements and also estoppel. And those mechanisms all have one thing in common. They tend to settle boundaries in accordance with actual use on the ground. So this is what Lord Justice Nugee said in Clapham and Naga. He said, "I regard it as one of the great virtues of the doctrine of adverse possession as it applied to unregistered land. Once neighbours had been in undisputed possession of their respective properties for 12 years, that gave them ownership of the land they each possessed, with the result that the boundary between their lands would follow the de facto position on the ground, without the need for anyone to go back to the historic conveyances by which their properties were first separated. The practical effect was to favour the claims of those who had long been in peaceful possession of land over those who had, or arguably had, a mere paper title. That, I think, tended to reduce the number of boundary disputes, which all too often arose great passions and usually cost far more than the property in issue is worth. And here is a quotation from Mr. Justice McGarry in Nielsen and Poole, where he said, "I must too bear in mind that a boundary agreement is in its nature an act of peace, quieting strife and averting litigation, and so is to be favoured in the law." Now, pausing there, Nielsen and Poole is the case which is thought to have originated the concept of the boundary agreement. That is a fiendishly complicated area of the law in itself. I'm not sure that it's going to be covered later, so I will briefly explain now what a boundary agreement is and what a boundary agreement cannot be. If a conveyance is unclear as to what it has conveyed, it is open to neighbouring landowners to reach an agreement about where the boundary is. That agreement is enforceable against successors in title because it is an agreement to clarify an uncertain boundary. In other words, it is not an agreement the effect of which is to convey any land, and the effect of that is that it doesn't need to comply with any of the statutory formalities. Now, there is a small exception to that introduced in a case called Joyce and Rigoli, which is that small, uncontemplated transfers of land in a boundary agreement do not make it void. But the starting point is that if parties are agreeing to clarify a boundary which is uncertain, that agreement can be binding on successors in title. If the effect of the agreement is to move a boundary, then it is not. So having said that, I just want to come on to another reason why boundary disputes, in my view, proliferate. And that is because the status of a land registry title plan is widely misunderstood. That is because the general boundaries rule is so widely not understood. This is the general boundaries rule. It's contained now in section 60 of the Land Registration Act 2002, and it is one of the most important provisions for all practitioners to be aware of. It states that the boundary of a registered estate, as shown for the purposes of the register, is a general boundary unless shown as determined under this section. A general boundary does not determine the exact line of the boundary. And to illustrate how this is problematic, in Clapham and Naga, my clients had owned two adjoining houses with a brook adjoining their gardens. And the evidence was that for 40 years, the land up to a fence on the far side of the brook had been in their possession, and that the fence had been treated for decades as the line of the boundary. The judge ruled that the land originally conveyed stopped short of that at the near bank of the brook, but went on to find that my clients had obtained title to all of the brook and the far bank up to the fence by adverse possession before title to Brook Barn was registered. Then Ms. Naga, the defendant, bought Brook Barn. She took the view that her land registry title plan showed the boundary lying to the south of the brook along my client's lawns, and relying on that title plan, she insisted on her entitlement to possession of the disputed land. And my clients were partly successful at trial, but lost on an important point about adverse possession. They lost that point again on a first appeal, and off it went to the Court of Appeal. And this is what Lord Justice Newey said, allowing the appeal, about how the judges below had got it wrong. I'm not going to read it out because I think it will be in the slides that you get at the end of the talk. But the critical point about this appeal is that it served as a very important reminder that land registry title plans only indicate who owns a piece of land and the rough location of that land. They do not indicate where the boundaries of that land are. And under the 2002 Act, the identification of boundaries turn on the application of the principles of law, which we will go on to explain. All of that is great news for lawyers, but not so great for surveyors. And notably, Livy Purvis, in her Times article about boundary disputes, marvelled that people would rather litigate than accept mediation or even a land registry map. And so the misunderstanding about the status of these plans is not, it seems, limited to judges. It shows just how entrenched is the instinct of people to rely on land registry title plans as establishing legal boundaries, but it is illegitimate to do so. So if you have a client who has started a boundary dispute based on a land registry title plan, you should think very carefully about whether to remind them of Fortinbras and his army and advise them to sound a very strategic retreat. It might be thought perhaps that if the law in England and Wales were changed so that land registry title plans were definitive, boundary disputes would be magicked away forever. That once was the case. The Land Registry Act of 1862 provided that anyone who wanted, or anyone who had registered their land, the maps accompanying the registration were required to show the exact boundaries of registered property. That caused huge difficulties, as the Transfer Commission's 1870 report found. It led to two immediate consequences, both of which were mischievous. It required people to serve notices on adjoining owners, and most importantly, it tended to force disputes upon people about boundaries when they only desired to remain at peace. And so it was the Land Transfer Act of 1875 which first introduced the general boundaries principle. So the general boundaries rule, that very important rule in English land registration law, is now coming to celebrating its 105th anniversary. And it's likely to be with us for some time to come. The last word can go to the Law Commission. This was what it said in its updating land registration consultation document in 2018. We have not considered wholesale reform of the general boundaries rule. We remain convinced that any move away from the general boundaries rule to exact boundaries would be unworkable. It would increase the cost of transactions and could provoke unnecessary disputes, perhaps making landowners feel that a move of the paper boundary would deprive them of land when in reality nothing had changed on the ground. So, for the foreseeable future at least, the general boundaries rule is here to stay, and it is absolutely fundamental that property litigators understand it. And it also seems that misunderstandings about the general boundaries rule may continue in the meantime to ignite boundary disputes where titles were previously quiet. That's what I'm going to say by way of introduction and scene setting. I now want to move on to Kate's slides. Okay, here we go. So this is the talk that Kate Trainer was going to give, and she was going to start with the general boundaries rule, which I have already explained. She's said there that the precise boundary, as I've said, is to be fixed by the deeds and the other principles that we'll talk about, and not by the land registration plan itself. And just to repeat, the leading case on that is Clapham and Naga in the Court of Appeal last year, in which, as I may have mentioned, I acted for the successful appellants. So that's enough about the general boundaries rule. How then do we actually identify where boundaries are? The starting point is always the conveyance, and what is sometimes called the originating conveyance. One does not identify a boundary simply by looking at the latest conveyance. The critical document which one must find is the conveyance which created the boundary in the first place, i.e. the conveyance which split one piece of land into a separate title, leaving a legal boundary between them. Because all a legal boundary is a theoretical, infinitesimally thin line between land into separate titles. So, this is the approach which was suggested by Lord Justice Lewison in Drake and Fripp in the Court of Appeal in 2011. Start by looking at the parcels clause in the conveyance. That is the bit which says this conveyance conveys the land more particularly described in Schedule 1, for instance. It is then necessary to look closely at whether or not the land conveyed is identified by reference to a plan. Sometimes there is no plan. Sometimes, particularly in the olden days, as it were, conveyances would convey land by reference to a description. They would use something like the land known as 63 Acacia Avenue. It is now far more common that there is a plan and that the parcels clause refers to the plan. But one must then review the plan itself and note whether the plan is said to be for identification purposes only, or whether it is used to define actually what is conveyed. You then look at the rest of the document, looking for other clues about what was conveyed, in particular perhaps obligations about repairing boundaries that might shed light, easements, that sort of thing. And you must also, of course, take into account the physical features on the ground at the date of the transfer. So coming on to plans then, first of all, what happens if a plan is referred to for the purposes of identification only? So a leading case on this is Strachey and Ramage, to which I referred briefly earlier. What Lord Justice Rymer said is its ordinary sense, by which he meant the phrase for the purpose of identification only, is that a plan so described is intended to do no more than identify the position and situation of the land. It is specifically not intended to identify its precise boundaries. The use of such a plan is therefore strictly only appropriate for a case in which the verbal description in the parcels identifies the limits of the land with adequate precision, since it is a formula which indicates that the verbal description is intended to be decisive in that respect. The attached plan is sometimes based on the Ordnance Survey, and although usually very accurate, the plan is unlikely to fix precise boundaries or even to show every physical feature of the land on the ground. So the court may use the plan to assist in understanding the description, mainly where the document's words are inadequate on their own and where the plan does not conflict with them. But the plan itself will not necessarily take precedence over other extrinsic evidence, such as evidence that there was a wall in place at the time, or a ditch, or something like that. And apparently where registration is required, the Land Registry's practice in Practice Guide 40 is that plans described as for the purposes of identification only will be rejected. But I think that's something that Harley will come on to address in his talk. Now, let's look at a little bit more detail at this phrase, more particularly delineated. In the upper tribunal, Judge Cook, in a case called Dunlop and Romanoff, had this to say: the general rule is that where a plan more particularly delineates the land conveyed and either the wording is unclear or the wording is clear but inconsistent with the plan will generally or normally prevail. In deciding whether the case falls outside the general rule, there are two general principles of great importance. So where the conveyance itself and the physical features on the ground do not clearly indicate what has been conveyed, the court can take into account extrinsic evidence, and if in doubt, the judge should prefer the interpretation that makes business common sense. So that is consistent with the ordinary principles of contractual interpretation. But the decision, like so many on the status of plans, underscores the importance of sourcing extrinsic evidence, contemporary conveyance, sales particulars, contracts of sales, things like that, and recognizing the commercial realities at the time of a transfer in boundary disputes. Now, what happens if you have both forms of words used? Now, that means that a conveyance says, more particularly delineated on the plan attached for the purposes of identification only. In other words, there's a conflict between the phrase, what is conveyed is delineated on the plan, and the phrase, but the plan is for the purposes of indication only. So HHA David Cook in Avon Estates and Evans said this: if both forms of words are used, as they have been in the present case, the draftsman has achieved neither one thing nor the other, and the two expressions may be said to be mutually stultifying. Coming on then to the next slide, which actually deals with delineation. So in Network Rail Infrastructure in Fremont, what was said was that where the wording of the contract or transfer indicates that the plan is not merely for the purposes of identification, but is intended to define the property, it will normally take precedence over a verbal description and over any physical features of the property, unless it is not clear enough to show where the boundary lies. So just to give an example, if a conveyance attaches a very, very detailed plan with very, very detailed measurements exactly of where the boundaries are and how they relate to other features on the ground, then that plan, if it is said to be for the purposes of delineating the what is conveyed, that plan will likely take precedence over everything else. If, however, the plan is said to be definitive of what is conveyed, but is at such a large scale or so unclear or so poorly drawn as to be meaningless, then at that point you must nonetheless look to the extrinsic features on the ground to work out what has actually been conveyed. So just on extrinsic evidence, what was said by Lord Justice Mummery in a very important case in Pennock and Hodgson, which should be always a starting point for practitioners looking for authority on how to construe a conveyance. What he said was that precise boundaries must be established by other evidence that includes inferences from evidence of relevant physical features of the land existing and known at the time of the conveyance, looking at the evidence of the actual and known physical condition of the relevant land at the date of the conveyance, and having the attached plan in your hand on the spot when you do, are permitted as an exercise in construing the conveyance against the background of its surrounding circumstances. They include knowledge of the objective facts reasonably available to the parties at the relevant date. So what is often said is that the ultimate question when construing a conveyance is, what would the reasonable man standing on the land with the conveyance and the plan in his hand think that he was buying? And that, in my view, is always a very helpful way of looking at things. These are some cases, earlier cases, which suggested that if the plan is not on its own sufficiently clear to the reasonable layman to fix the boundaries of the property in question, topographical features may be used to clarify and construe it. That's another decision of Lord Justice Mummery, who went on to say that where the plan is not sufficiently clear, the court can and in my view must have regard to all admissible evidence with a view to elucidating the true sense of the transfer. Such evidence will not, of course, include the parties' prior negotiations or their expressed subjective intentions as to the land to be transferred. So, in accordance with usual principles of contractual interpretation, negotiations and evidence of subjective intention are irrelevant. Only objective facts, such as what was on the ground at the time, are admissible. Now, extrinsic evidence or examples of extrinsic evidence, which are often relevant, are the agreement for the sale of the property, so the contract for sale. Auction particulars can sometimes be very useful for indicating what is on the ground. So in Clapham and Naga, for instance, one of the things before the court were the particulars of an auction sale, actually referring to the existence of the brook and the fence. And the judge, I think, relied on that when making findings about the physical features that were on the ground at the time of the relevant conveyances. Also, what might be relevant are answers to preliminary inquiries in the conveyancing context, but to stress no evidence of subjective intention, such as pre-contractual negotiations. So that is the basis of how to construe a conveyance, subject to a few things that Harley is going to come on to. I think I'm now going to surrender control. Harley is going to take over Kate's talk, and I'm going to turn myself off.
Thanks very much, Tom. I think I have control. I'm not entirely sure yet. Yes, I think I do. So we've divided up Kate's talk so that Tom has covered all of the relevant legal principles at play when answering the question of where is a boundary separating two properties. And I'm not going to revisit those, but as Tom has said, the essential question is, in the first instance, one of law. What does the conveyance suggest? And you answer that by applying the normal principles of contractual interpretation, and you do that in the context of the property known at the time of the conveyance. But another point to have in mind when dealing with the location of a boundary is certain presumptions that the courts have developed. Well, I can see someone's email inbox. Tom, it might be yours, it might be Jasmine's. It seems to have gone now. But the presumptions, I'm going to cover a few of them. First one is not really a presumption at all, actually. It's quite the opposite. If you were to take some legal advice about boundaries from an older family member, I would bet good money that they would talk about T marks. And T marks generally mean marks in the title plan or the transfer plan on a boundary feature as a T. So a T abutting a line. People will say that the presence of a T mark on a particular line means that you own it, that you are liable to repair it, or some variation of those pieces of advice. And I'm afraid there is no such presumption at all, and it's very bad advice to just proceed on the basis that T marks as a matter of law mean anything at all. They can, in a particular conveyance, mean that a particular boundary feature is owned by one party. They might also mean that a particular party is liable to repair that particular boundary feature. But at best, they're admissible factors, admissible evidence in the construction of the conveyance as a whole. The two cases here, first one, Seeks and Derwent, that was a case in which, on a proper construction of the conveyance, the T marks were intended to represent an existing boundary feature, and critically were intended to represent ownership of that particular boundary feature. But as the Court of Appeal in Lanphier and Chandler said, there's no presumption in law that a boundary feature belongs to the person with respect to whom the T mark is located. So that's the first point we really wanted to emphasise, is that T marks have no established default meaning whatsoever in the context of boundary disputes. Coming on then to presumptions, let's see if I can do this. Yes, presumptions. Another thing, again, if you were to take advice from certain older members of your family, another piece of advice you would often get is that you own the left-hand fence in your property when you're facing the house, or the opposite, you own the right-hand fence when facing your house. No, that's entirely wrong, I'm afraid. But there are some presumptions which operate in the construction of conveyances and can be of assistance in boundary disputes. And we wanted to look at three of them in particular. First of all, the hedge and ditch presumption, the presumptions around fencing, and the presumptions around roads. So hedge and ditch may well be familiar to many of you. At its simplest, when a piece of land is separated by a hedge and a ditch on the other side of that hedge, there is a presumption that the boundary is on the opposite side of the ditch. So in other words, the ditch is on, if you're looking at the hedge, the boundary is on the side away from the ditch. And it's a sensible rule, because the idea is that if you are building the hedge, you would have built the hedge on your land behind the hedge, and the hedge would have been the boundary. The other point is, the other reasoning for it is that the owner of the ditch would want to make the fullest use of their land and would have built the ditch right up against the boundary to their land, being the hedge. It's a rebuttable presumption, but it's quite strong to rebut. One instance might be where the ditch is a natural feature. So obviously, if the ditch is naturally created, the reasoning for the presumption doesn't work at all. It doesn't work if there are two ditches on either side of the hedge, obviously. But it can be a really useful starting point, particularly in agricultural contexts, to understand where the boundary might actually be in law. But again, it can't contradict the clear words of the express conveyance, and it can't contradict what the conveyance otherwise says. Let's talk about fencing. So fencing is an area where there is another presumption, and the presumption here is that the boundary is on the side of the land where the posts and the rails are that support the fence. So in other words, that the panels will be on the side of the adjoining owner. And again, it's very similar in reasoning to the hedge and ditch presumption, that the person who owns the land will place the supporting posts on their land and attach the panels on the other side and make the maximum possible use of their title. Again, rebuttable, open to challenge by contradictory evidence, but it is something to have in mind when looking at boundary disputes. And roads, there's 3 points that Kate wanted us to emphasise on roads. First is that where the boundary of a property with a road is situated with a road, the boundary is in the middle of the road. And the idea here is that there's a presumption that adjoining owners own the subsoil as far as the middle of the road. In practice, that's not that helpful, because if it's a public highway, then the highway itself vests in the highways authority. But in terms of the boundary, the presumption is, in this situation, that the boundary would go down the centre of the road. There's another presumption on a different factual situation, which is called the hedge-to-hedge presumption. So if you've got a road in between two parcels of land and the road is bounded by hedges, the hedge-to-hedge presumption asserts that the highway extends the entire width of the area between the hedges and is not confined to the constructed portion of the road. And finally, conveyance of land next to a highway. There's a presumption that when land is conveyed that's next to a highway or adjacent to the highway, the conveyance includes that part of the highway which adjoins the land and is owned by the vendor. So if the vendor then owns more than half the road, the vendor's interest is transferred and not merely up to the halfway line. That's all I want to say by way of overview of the general principles, and thanks again to Kate for preparing those slides for us and for her notes. Here's a talk I actually prepared, which is, I'm afraid, much more boring than the legal principles, because it's about the procedure for the determination of a boundary. So we're moving on now from legal principles. So Tom set out all of the normal principles at play when you're trying to understand where the location of a legal boundary is. And now we want to consider procedurally how you get a determination of that in a court or tribunal. And there's three that I wanted to highlight. First is determination by the land registry itself or by the tribunal if there's a dispute. Secondly, by the court, and that could be a claim by an owner for a declaration, possibly coupled with other relief that the boundary is where the owner says that boundary is. And the third is by agreement between the parties. And it's really the first one that I'm going to spend my time on, because the rules around court claims for boundary disputes are in principle absolutely no different from any other Part 7 or Part 8 claim. And this isn't a talk on civil procedure. Similarly, boundary agreements could be the talk of an entire separate topic, because they raise distinct problems and issues. But all three of them are ways in which, if you're faced with a dispute as to the location of a boundary, options for you to get a binding determination as to the location of that boundary. And I want to start, and as I say, spend actually most of my time on the land registry process, because it is a very fiddly procedure. And possibly, I'm racking my brains earlier, possibly one of the only areas of the FTT's jurisdiction where it's not actually possible to just issue a claim in the FTT as to the location of a boundary. So the FTT's jurisdiction really is ancillary to the land registry's jurisdiction to determine the location of the boundaries. So I'm going to go into the detail in a minute, but just in general terms, how this works is this. So the owner of a registered estate can submit an application to the land registry for a determination that the boundary is in a specific location. And you'll remember under section 60, as Tom said, in general terms, boundaries in title plans for registered titles are general boundaries only. So this is a bespoke procedure under section 60, which enables a person to make an application to the land registry to say, here's my evidence, please determine that my boundary is exactly where I say it is, and then land registry will make a note on the title. And you've overcome the general boundaries problem. If you put your application in and it's valid, the land registry notifies the adjoining owners, and then you have two options, or two possible routes out of that. The first is almost never happens, is there are no objections. So your neighbouring owners don't raise any problems whatsoever with the application. Land registry will complete it, they'll make notes on the appropriate titles, and you have a determined boundary for that particular title. As Tom said, boundary disputes are famously emotive, famously problematic, and I am not aware of any case in my own practice where someone has made a determined boundary application, no one's objected, and it's been completed. I'm sure it happens, and I'm sure it probably happens where people miss it and miss the post, but in principle, in practice, what's most likely to happen is this second option, which is objections. So if your neighbours then object to the application and the application is not groundless, the objection is not groundless, the land registry can only dispose of that objection by agreement. So the land registry can't enter in a dispute resolution mode and determine which party is correct. It can only dispose of it if both parties agree that the objection can be disposed of. And again, in practice, that just isn't going to happen. So what the 2002 Act says is that the land registry must refer the matter to the FTT for determination. The FTT basically holds a trial in a specialist division, and the outcome of that trial determines what HM land registry need to do with the application, and it will be an order from the FTT to the land registry saying either yes, the applicant's correct, give effect to it, potentially subject to some modifications, or no, it's completely wrong and the application must be dismissed. That's it in very general terms. What I'm going to do is just spend some time on the detail of it. I'm not going to go through all of these slides in a huge amount of detail because they're quite boring. To be frank, the rules are incredibly dry, incredibly technical, and I think it's probably more valuable if you have the slides and you know where to go in the event that you do have to make one of these applications or you're involved with one of these applications. But I do want to just go through them in a little bit of detail and just summarise really the key takeaway points. First part is where are we looking here? It's part 10 of the Land Registration Rules 2003. The actual primary legislation is section 60 of the 2002 Act, but the procedural rules are all set out in the secondary 2003 rules. The application itself for a determined boundary to the land registry can only be made by the registered owner of the land. So can't really imagine a situation where it might happen, but it can't be any Tom, Dick or Harry. It's got to be the registered owner. And clearly, in the case of registered land, this only applies to registered land. If you're dealing with an unregistered piece of land, you could couple this with an application for first registration. But the first point to note is that this is only really of relevance to registered land. And if you're not prepared to try and get the land registered, you can't use this procedure at all. The application itself, there's a prescribed form. The land registry has prescribed forms. This is form DB. It needs to be accompanied by a plan or a plan and a verbal description identifying the exact line of the boundary that you're claiming, showing sufficient surrounding physical features to allow that general position to be drawn on an OS map. And of course, your application has to be accompanied by evidence to establish the exact line of the boundary. As I said in my little overview flowchart a moment ago, what then happens is the land registry notifies adjoining owners, subject to the land registry being satisfied that the plan or the plan or description is sufficient in that it identifies the exact line of the boundary claim, that the applicant has shown an arguable case that the exact line of the boundary is in the position they say it is, and that the registrar can identify all of the owners of the land adjoining the boundary and has an address. And if the registrar isn't satisfied on those, they must cancel the application, and that'll be the end of it. So in practice, if you are submitting these applications, it's really important that you put in sufficient detail with your application to satisfy all of these matters. I don't actually think it is a requirement for the applicant to identify all the owners of the adjoining land, but I think in practice it's worth doing, and it's something I've seen done in practice as well, where the applicant says, look, these are the names and addresses of the adjoining owners, please give them notice, because it just saves the land registry having to do that work and reduces the risk that they say that this is insufficient. And I agree that they're becoming less rare in terms of people making the applications. I'm not sure why that is, if it's just a kind of general awareness, because it is a very weird procedure, because you have to approach it with the mindset that I'm not issuing a claim for a declaration. I'm actually approaching this as an application effectively to modify the registered title. I mean, that's kind of what it is. And it's only then that you have that opportunity to go to the FTT. So yes, I'm not sure why they're rare, because maybe we'll come on to this later. I mean, in terms of advising people whether to issue a claim or do the DB route, my view is do the DB route, subject to certain qualifications, but generally I think it's the better route. I think Jasmine's having problems, so what I'm going to try and do is share my screen. Let's see if this works. Screen one.
Whilst you're pondering that, and just that no one's listening to silence, there's been a question about adverse possession and whether the starting point is always 10 years adverse possession. In other words, can you show factual possession, intention to possess to up to 10 years? The answer to that is that one must always start with the originating conveyance to see if the original boundary can be identified. If you can, the next question is whether the original boundary has been moved, either as a result of a boundary agreement or by adverse possession or by estoppel. So it may well be that 10 years of adverse possession on the ground does trump the original paper conveyance, but the paper conveyance is still the starting point. I think we now have the screen back, so I'm going to disappear.
Yes, it does look like we have the screen back. Landmark Chambers has 3 screens, it says. Okay. Thank you, Tom, for that. And yeah, the adverse possession point is something I want to come back to as well in terms of jurisdiction. I think where I got to was this. Land Registry, on receipt of the application, had to be satisfied with these certain matters. If they're not satisfied, they'll cancel it. If they are satisfied that it's valid and you've covered those 3 points, there's then a prescribed period for objections for neighbouring owners, and the default position is it's until 12 noon on the 20th working day after the date of issue of the notice. But the Land Registry can extend that, and they can also extend it upon a request from a person who receives the notice. Unless anyone who receives that notice objects within the time fixed, the registrar must complete the application, and effectively the boundary is determined, and the application is completed by an entry in the title with particulars as to the precise location of the boundary in question. And that will be on the registered title of the applicant, but there'll also be a note on the registered titles of any adjoining land which are affected. Objections. It's 20 working days, as I say, subject to extension by the registrar. If there is an objection, the first hurdle for the objector to overcome is the objection must not be groundless. And in practice, it's an incredibly low bar, I find. There's no definition of it in the Act at all. If it's not groundless, if the objection is not groundless, then the Land Registry gives notice to the applicant of the objection, and they can't determine the application until the objection has been disposed of. And as I said earlier in my little summary flowchart, there is no power for the Land Registry to dispose of the objection other than by agreement of the parties. And in practice, that just simply doesn't happen. So if it can't be resolved by agreement, the registrar must refer the matter to the FTT. FTT, I'm sure everyone is familiar with, but it does go to a land registration division of the property chamber. I won't cover all the rules on what happens when the property chamber receives it, but in very general terms, the FTT will give directions for a hearing. When the hearing happens, which in substance is a trial, Tom, I don't know what your experience is, but the FTT in other areas is quite informal. With determined boundary applications, they do have a bit more formality, and they do conduct the case like a trial. The tribunal judge will be a specialist judge. They'll apply all the usual principles that Tom set out earlier in the talk. You'll have expert evidence, you'll have factual witnesses, and the judge will have to determine whether the boundary is in the location contended for by the applicant. One of the most significant practical points about determined boundary applications is that the FTT has a very limited jurisdiction to resolve the dispute. So under Section 73, what the FTT is dealing with is the matter referred to it by the Land Registry. And this, as you probably won't be surprised, has caused all kinds of problems as to what the matter is that's been referred to the FTT, and therefore what is the extent of the FTT's jurisdiction to resolve that dispute. And I've got some quotes here from a case I did in 2023, which was a determined boundary trial in the FTT in front of Judge Payton. And I mentioned I'll come back to the adverse possession point, and this is dovetailed quite nicely, because what happened in this case was that the applicant, as for the respondent, the applicant asserted in their skeleton argument that because the applicant had been in adverse possession for the relevant period under the 2002 Act to be entitled to apply for registration of the disputed land, that was a basis for the FTT to conclude that the boundary was where they said it was. That wasn't an answer at all, actually. It was a really bad point in law, because under the modern adverse possession regime, all 10 years allows you to do is apply to be entered as the registered proprietor of the relevant estate. It doesn't extinguish the title to the land or extinguish the claim to recover the land under the Limitation Act does with unregistered land. So actually, in law, it actually made no difference whatsoever that this person was entitled to make the application. They never made the application. Anyway, we had to deal with the point, and the way we dealt with it was through jurisdiction. That the FTT did not have before it an application to enter someone as a registered proprietor by way of adverse possession. They had a determined boundary application, and the FTT judge agreed entirely. And there's a really useful summary of the case law at paragraph 11 of the judgment. And first of all, he sets out the essential jurisdiction of the FTT is to consider the actual application before it, to which the FTT may give effect to it or cancel it in whole or in part. The primary jurisdiction is not, therefore, a general and free-ranging jurisdiction to make a declaration or determination of the location of the boundary, wherever it might be and on whatever basis, or to grant any other relief. This is probably one of the most important limitations, as I said, of the DB procedure, because as an applicant, you can really enter problems. If your determined boundary application is actually quite compelling, but the location you have identified as being the boundary is not quite right, the FTT takes a different view that you're broadly right on the law, but for whatever reason, the boundary is not quite where you say it is. You then get into this debate as to whether this is the matter which can be referred to it, and whether the FTT can do anything other than give effect to the application as it was made or in some other form. And the conclusion seems to be that the FTT can direct the Land Registry to change the application, or rather to give effect to the application in a slightly modified form, but probably not anything substantially different from the application as made. So if there is a prospect actually of the court or the FTT concluding that it's not quite where you say it is, that causes real problems to the FTT actually having the power to make the order. Other problem it causes is for respondents. So again, in the Ali case, my client put forward effectively a counterclaim. It wasn't formally a counterclaim because there's no provision for counterclaims in the FTT. But we had our own version of events as to where the boundary was. The FTT has no power whatsoever to order something on any kind of formal counterclaim. The best that can happen is the FTT can say, I don't agree with the applicant, I agree with the respondent, but all of those conclusions will be simply essentially findings of fact, probably findings of fact sufficient to be an issue estoppel to prevent any further claims, but it won't be a determination which will give effect formally to the location of the boundary. So that really is probably the most important thing to bear in mind when you're considering whether this or a court claim. Okay, bringing it back to my summary again, this is for registered land only. You can't use DB applications for unregistered land, but you can, in theory, make the application at the same time as first registration. You commence that procedure by applying to the Land Registry to determine the location of the boundary. It has to be submitted with evidence. There's no objection, it's completed. If there is an objection, and that objection is not groundless and it's made in time and it can't be resolved by agreement, the Land Registry will refer the matter to the FTT. The FTT has jurisdiction limited to determining the matter, and it will hold a trial giving effect to its conclusions, complete the application, complete it subject to modification, or reject it. That is the FTT procedure in summary. I'm not going to say anything about court, as I said earlier, because I think it will all be familiar to everyone. But in very general terms, obviously, if you have a dispute over the location of a boundary, entirely open to a claimant to bring a claim in a court, whether that be the county court or the high court, for a declaration that the boundary between two properties is where they say it is. That's often coupled with other relief, so an injunction to stop using that particular piece of land, remove things that are on it, could include a claim for damages. Almost certainly going to be Part 7, but in theory could be Part 8 if there are no disputed facts. Could also be raised as a counterclaim in, say, a possession claim, potentially, or just as a claim for a declaration by someone else. It's the normal CPR apply. There's nothing special in the CPR about boundary disputes. And the substantive approach of a court is exactly the same as the FTT in terms of resolving the dispute. They would apply all of the law that Tom set out as to the legal question as to what the conveyance means, assess the location of the boundary factually in the same way. Again, expert evidence in the form of surveyors, almost certainly going to happen. So in substance, it's going to be the same, but obviously the court is not limited in the same way by the LRA 2002 as to what it is determining. Going to wrap up this section of our talk then just with some pointers on where to go if you are thinking about effectively where to issue your claim. I know it's not really issuing in the FTT, but where to frame your dispute. First question is always going to be, is the land registered or not? Because that's going to be determinative. What relief do you need? The FTT can't do anything other than determine the application. The FTT can't order damages. They can't make an injunction, anything like that. That's not to say that you couldn't go to court after you've been to the FTT relying on your FTT determination, but you can't wrap it all up in one go. Timing, my experience, and this is purely anecdotal, is that determined boundary applications are determined relatively quickly once the FTT kicks them off. Once the land registry kicks them off to the FTT. Generally, I find that 6 months actually, which is considerably faster than a trial, particularly once you factor in all the case management stages of a trial. So if timing is an issue, the FTT can be a good choice. The judges there are also excellent because they're specialist land registration judges. They deal with these type of cases all of the time. In the county court, you are at the mercy of the court as to who you're listed before. You may well get a specialist judge. You may well get someone who's never done property law. So that's another point to bear in mind. Costs really actually, the principle of costs at least, not really determinative either way, because in the FTT, at least in the land registration division, that is, costs are recoverable. That's unlike Section 27A disputes, landlord and tenant service charge disputes, things like that. Generally, those disputes there's no general rule that the loser pays, but that's not the case in boundary disputes. So costs is really neither here nor there.
Long-term reversions Harrogate Limited, a decision handed down last month by the Land Registration Chamber of the First Tier Tribunal, where I acted for the successful applicants for registration with title to a loft space excluded from their demise. The answer is that you are very unlikely to be able to succeed on adverse possession because, in fact, you obtain title via another route, via something called the doctrine of accretion, which is actually a form of estoppel, but not adverse possession, unless the presumption that the doctrine is engaged is rebutted, and it is very hard to rebut the presumption. So if you look at that, I've posted the judgment on LinkedIn and it's available from the First Tier Tribunal, the answer to the question and all of the weird principles which apply when a lessee is in adverse possession of their landlord's land, those are all set out there. Hopefully I've now got control, so I can move on to what I was going to talk about next, which is thrillingly the role of experts. It was very tempting to title this talk "Keeping Surveyors Within Boundaries," for the pun value, if nothing else. But any talk about the role of experts in boundary litigation should start with an explanation of what the expert's role is not. So, here is a quotation from the recent Supreme Court judgment on experts. Said, this is Lord Hodge saying, the expert must not usurp the functions of the judge as the ultimate decision maker on matters that are central to the outcome of the case. And here's another decision. This is from Liddell and Middleton, 1996 judgment of Lord Justice Stuart Smith, who says, we do not have trial by expert in this country. We have trial by judge. So I start with these salutary warnings because there is a significant degree of expert overcreep in boundary disputes, which more often than not ends in disaster. And the best way to understand the limited role of an expert in a boundary dispute is to look at a case where the expert got everything absolutely wrong. And this was a case that Harley's just mentioned, the case that he did in the First tier tribunal land registration chamber on an application for a determined boundary. And it was one of those cases like those contemplated by the Land Transfer Commission in 1870, where actually an application to determine the line of a boundary resulted in protracted litigation. This was a case where, from reading the judgment, it is very obvious that the applicant's expert reports failed to withstand the bombardment directed at it in Mr. Harley Ronan's submissions. So, oh, sorry, there's just one other point to flag there. At the bottom of the slide, actually, in the Chewy case, there is a very useful statement of the role of an expert, which is that expert evidence may be of assistance insofar as it consists of matters of scientific, technical, or other specialized knowledge which are outside the judge's expertise, but experts should not give their opinion on issues of law, like the location of a boundary. So now coming on to Harley's case and Tribunal Judge Patton. This was what was the framework for the expert's involvement. The precise line A, B, C, D contended for by the applicant is entirely based on the report, opinions and drawings of a building surveyor, Mr. Singleton. It is not, for example, based on any specific evidence as to the historic location of any boundary feature, such as a fence or e.g. evidence of possession or other legal principles. Mr. Singleton begins his report of the 31st of August with what I regard as the somewhat surprising statement that he has been instructed to supply my professional opinion on the exact line of the legal boundary between the properties, while also noting that the applicant's Section 60 application was based on a report and plan I previously prepared for him. Much later in his report, he appears to accept that surveyors do not have the authority to determine a legal boundary. But since this comes at the end of an entire chapter purporting to set out the law and procedure in relation to determining legal boundaries, it appears that he used the word authority in the sense of binding authority. He clearly believes that his opinions on the law and citations of case law carry some weight. With the greatest of respect to Mr. Singleton and other members of his profession, the opinions of surveyors, whether they are chartered, building, or even specialist boundary surveyors on the exact line of legal boundaries, are of no relevance. This is not a purpose for which expert opinion evidence is required or even permitted. It is a question of law and construction for the court or tribunal determining that issue. Despite this somewhat obvious point, reports are frequently produced to this tribunal which contain such legal opinion and argument, often at length and with citation of authority. This report is a prime example of this. He then set out some of the things that have been said in the report, and the judge then said, for the reasons set out above and in the submissions of Mr. Ronan, I consider that all of those contentions are utterly wrong. So the surveyor trespassed into the law and got it all wrong. The judge didn't stop there. This approach, accompanied by a lengthy but selective purported recitation of legal principles and authorities, illustrates the dangers of surveyors usurping the function of lawyers and ultimately the court or tribunal and producing for a client a purported exact boundary line based on an incorrect application of legal principles. The proper role and expertise of surveyors is in surveying and measuring and in producing scale plans displaying those measurements. It is then for the parties armed with such measurements and plans to make their legal and evidential arguments to the court or tribunal, which will then decide upon them. Any detailed scale plan produced may then prove extremely useful in reflecting and depicting the decision made. Too often, and this is a very important warning, parties and surveyors appear to misunderstand this, and so put the cart before the horse by basing their legal arguments as to the precise boundary on nothing more than a surveying and scaling exercise from conveyance, registered title, filed plans, and or OS plans first conducted by a surveyor. I pause there because a very important point is made here. There is an industry of so-called boundary surveyors who claim to be specialists in resolving disputes between landowners, and many property owners in my experience, and in the experience of the first tier tribunal and indeed the courts, seem to consider that their first port of call whenever they find themselves in a boundary dispute is to go to a boundary surveyor. And they also seem to understand that a report produced by such a surveyor shows where the legal boundary of their property actually is. And a brief Google search for boundary dispute surveyor shows that the market out there is replete with firms of surveyors boasting of their ability to understand plans and conveyances and to identify where a boundary lies. And worse than that, a lot of them are advising the public at large that the first port of call when a boundary dispute arises should be them, a boundary surveyor. And in my view, that is very unfortunate for members of the public and for landowners. it is regrettable that so-called boundary surveyors are not clear that their role is limited simply to identifying features on the ground, perhaps commenting on aerial photographs. And I have to say, I'm not sure that the RICS guidance is helpful in this respect, because RICS also recommends to the public that if faced with a boundary dispute, they should in the first instance seek the advice of an expert surveyor. But in my experience, and in my view, in most cases, that would not be appropriate. The first port of call in a boundary dispute should be a specialist property litigation solicitor. Surveyors can draw what they see, but only lawyers can advise on where a legal boundary actually is. It is a question of law and not of surveying, and that cannot be stressed enough because it is so widely misunderstood. And there's some Court of Appeal authority to that effect. This was a case called Kuligovsky and Kenwood, 2003, and the recorder in the judgment, which is on appeal, had said this: in summary, this case rested largely on findings of fact. In respect of the trespass, I prefer the evidence of the defendant's expert to that of the claimant's surveyor on the interpretation of the plan. Now, you'll immediately be able to see what has gone wrong there, and this is what was said. Oh, no, my screen is frozen. Okay, here we go. This is what was said by Sir Martin Norris in the Court of Appeal. Said two objections may be taken to that. First, a question of construction of an instrument, though its outcome may be influenced by the surrounding circumstances, in particular by the topographical features, is a question not of fact but of law. Second, and more important, evidence of an expert witness's opinion as to the interpretation of a conveyancing plan is inadmissible. And so, if a landowner at the outset of a boundary dispute goes to a boundary surveyor, more often than not, they will end up pouring petrol onto the flames. If they go to a specialist solicitor, they are far more likely to end up pouring on water. So what role does a surveyor have in a boundary dispute? Here is some guidance given last year by Mr. Justice Zaccaroli in the Chancery Division. What he said is that the reports of experts are useful to the extent that they identify and collate potentially relevant evidence in the form of ordnance survey maps, plans from prior conveyances and photographic evidence, and provide an explanation as to why much of that evidence is of no assistance. I do not think, however, that their conclusion constitutes admissible expert opinion. The ultimate question is where the boundary lies. That is a question of fact to be determined by the court. Expert evidence may be of assistance insofar as it consists of matters of scientific, technical, or other specialized knowledge outside the judge's expertise. And in that case, he said, there does not appear to be any particular specialized knowledge which the experts have brought to bear in expressing their conclusions based on the evidence they have collated. I am not bound to accept their conclusion, but must analyze the evidence myself in order to decide where the boundary lies. So, key takeaways from all of this. First, expert evidence may not actually be needed at all for the determination of a boundary dispute. I have done many without calling a single surveyor or without having any expert report before the court. Secondly, at most, a jointly instructed expert might be required to produce a detailed, high-resolution, scaled plan of the boundary in dispute and all surrounding features. And as Tribunal Judge Peyton explained in Harley's case, such a plan can be very useful for the court when expressing in an order what it's decided, i.e. plotting on a plan attached to an order where it is found that the boundary is. Where you are trying to construe very old conveyances, then expert evidence might be necessary to assist the court to make findings of fact about features then in existence on the ground. Also, that may very obviously be done by surveyors identifying evidence of relevant features once on the ground, like the old fence posts, banks, stumps in the ground, trees, that sort of thing. Experts can also be useful for analysing historical aerial photographs, but, and this is a salutary warning, I think, unnecessary expert evidence may confuse non-specialist county court judges just as much as it often confuses clients. So, reminder, if you're in a dispute about whether you need expert evidence or not, the test is set out in Part 35 of the CPR is, first, is expert evidence necessary to decide an issue rather than merely helpful? If yes, it should be allowed. If it is not necessary, will it assist the judge in determining an issue? If it would assist, but is not necessary, then the court should consider if the expert evidence on that issue is reasonably required to determine the proceedings. Now, you can see that there may well be boundary disputes where that test is not made out, and you can see that there are boundary disputes where, in a limited way, that test is made out, whether that's in respect of a clear plan showing the judge in detail what's on the ground, or whether it's showing perhaps evidence of old features which might once have been boundary features. But it should never be assumed, just because it's a boundary dispute, that you will need expert evidence. So just wrapping things up then, some lessons for practitioners. The first point is that you should be ready to explain to your clients if they are relying on a boundary survey that they've already got, which purports to identify the line of a boundary. Be ready to advise them that they might not be able to rely on that plan, and indeed probably should not do so. In other words, the first thing, if someone's got a surveyor's report, might be to let them down about its significance. Then the next point is to think very carefully before issuing a claim about advising a client to get a boundary survey done. Is this a case where the cost can be justified, or is it in fact a case which can be dealt with in other ways? Once you've issued your claim, think very carefully about whether expert evidence is required by reference to that test. Don't just assume that it is because it is a boundary dispute. This is perhaps the most important point. Always give very clear instructions to the expert and clearly limit what it is that they are required to do. And finally, always instruct experts not to offer their opinion on where the boundary is. Their report should be absolutely silent on that, because it is not their job. And if they venture into expressing such an opinion, they will end up like poor Mr. Singleton in front of Harley Ronan and be torn to shreds in cross-examination or in submissions, and your client will not come out of that well as a consequence. So that's all I've got to say about experts. We now have scope for some more Q&A. I've been keeping an eye on the questions which have been coming in. Harley, there is a question, or someone has asked whether we can explain how adverse possession of registered land works in the new regime under the 2002 Act. Is that something you could answer?
Yeah, well, why don't we stay for another hour and I can do that. But in general terms, I think I said earlier actually, all that happens under the 2002 Act is that if you are in possession of land for the requisite period, the requisite 10-year period, you are then entitled to apply to the land registry to be entered as the registered owner of the title relating to that land. And it's a fundamentally different regime to the pre-2002 Act situation, because in pre-2002, the requisite amount of possession was sufficient to extinguish the title of the paper owner. You didn't need to do anything more than that. So really that's how it works. Once you've got your 10 years possession, and 10 years possession is, sorry, the tests for possession are themselves no different post 2002. Powell and McFarlane, I think it is, Tom, sets out the ingredients for legal possession, what you need to do. Ian Graham in the House of Lords, none of that's changed in terms of whether the quality of use actually meets the requisite tests for possession. Once you've had your possession, though, for the 10-year period, it opens up that entitlement to apply to be entered as the registered owner. And the biggest difference under the 2002 Act is that the existing registered owner effectively has a right entitlement to object with no reason, and that defeats the application. So in practice, it's a far more restrictive regime, and it's why it didn't work in the alley case that we've been talking about, where the applicant said, I'm the owner of this land by way of adverse possession, and therefore that's why you should say the boundary is where I say it is. Doesn't work like that in the FTT, because the FTT doesn't have jurisdiction that extends to peripheral matters like that. Yes, I think that's that cover it, Tom.
Yeah, and of course, just to be aware that the Supreme Court last a few weeks ago handed down a very important decision in a case called Brown and Ridley about applications under Schedule 6 of the 2002 Act for title based on adverse possession. What they found critically was that the 10-year period of reasonable belief that you owned the land in a boundary case needed to be any 10-year period and not a 10-year period ending on the date of your application. So that settled the point that was causing some difficulty in the Court of Appeal and below. Someone has asked, what questions would you put forward to an expert before they inspect a boundary? That, I think, depends. If it's a simple case where the boundary is a small garden in an urban area, I would simply say to them, please draw a plan of everything that you see with accurate measurements. If it's a case where you're trying to identify the boundary based on an old conveyance, I would be saying to them, please will you walk up and down the land and make a note on your plan and in your report of any feature that you see that might once have been a boundary feature. Don't offer any opinion on whether it demarks the boundary or not, but if there's a fence post that you find in the ground or a little bit of iron or concrete that might once have had a fence post attached to it, those are the sorts of things which can assist the court in making factual findings about what was on the ground at the time of the conveyance that they're trying to construe. But really, the main job for a surveyor is, as I said earlier, they go onto the ground and they draw what they see and they plot what they see in great detail. And in many cases, they will need to do no more than that. But really, it depends slightly on the scope of the dispute. But what I would always advise is make sure the expert is instructed not to offer any opinion on where the line of the boundary is. Now, someone has also asked for some advice on what you should do if you can't find the conveyance, which interestingly comes up a lot because one of the consequences of land registration is that you no longer have a wonderful packet of old deeds when you buy a property, and the land registry doesn't tend to have filed copies of everything. So if you can't find the original conveyance, my top tip is that the first place to look obviously is the land registry to see if it's filed against your client's title. It may not be, in which case the next place to look is the title to all of the surrounding properties or neighbouring properties to see if you can find the relevant conveyance filed there. And sometimes this does involve downloading everything you can possibly get from the land registry and trying to piece together the conveyancing history to see if any of these documents is the relevant one. If you can't find it at the land registry, you can ask predecessors in title if they've got it. You can ask neighbours. If no joy there, you can sometimes ask an archivist or a local historian to see if they can do some research. And if not, and you cannot actually identify the conveyance which created the boundary, then some of the presumptions are engaged. But really the answer then is identify where the boundary features are and consider whether as a result of constant use of the land on either side of that boundary, say that there is an implied boundary agreement or even an express boundary agreement or adverse possession or estoppel, which essentially fixes the line of the boundary along the boundary feature. That is, in my view, what it is best to plead in that sort of situation. Harley, could you possibly answer the question, what if the 12 years of adverse possession happened prior to the disputed land being registered?
That is quite complicated, I think. I suppose it depends on what's actually happened because on one view, the person who applied for registration was not entitled to be registered as the owner, were they? Because they didn't have title anymore. Their paper title would have been extinguished. So possibly rectification, I think you might be looking at there. There are some complicated transitional provisions in the 2002 Act that deals with what happens if, in the case of registered land and the so registered land where the possession has accrued whilst it's registered, but pre-2002. But in that situation, interested in what you think, Tom, but in that situation, it sounds like the person who was actually registered was never entitled to be registered.
This actually, if you read through the judgments in the Court of Appeal in Clapham and Naga, in which I think, as I may have mentioned, I acted with the successful appellants, the judgments go through all of this in detail because that case was all about title that had been extinguished before first registration. First registration under the 1925 Act, and then what happened with all the subsequent conveyances under the 2002 Act. So the answer is that if you're in adverse possession for 12 years before registration, the Limitation Act applies. So paper title is extinguished and you are entitled to apply to be registered. And what Clapham and Naga decides is that if that is the case and someone is subsequently registered as the proprietor of the land to which you've extinguished title by adverse possession, either the general boundaries rule operates so that in fact registration doesn't mean anything because there is no defined boundary. And what the general boundaries rule means is that all that the person gets registered with is the land up to the line of what was extinguished by adverse possession before first registration. If it's not a case where the general boundaries rule applies, then as Harley said, it's a case where you've got wrongful registration, and your remedy is to apply for rectification of the register, and that opens up a whole new and very complicated can of worms on which you must advise your client to take specialist advice. Just having a look on the 5 minutes more. Someone else said, can a lessee obtain adverse possession over the, hang on, mine keeps flicking up. Can a lessee obtain adverse possession over the freeholder's wider title? And could the extended title last longer than the original lessee title? So the answer to that is that if the lessee is in adverse possession of their landlord's wider title, the doctrine of encroachment is presumed to be engaged. What that means is that the lessee is stopped from contending that they have actually extinguished their landlord's title, and the law presumes, in fact, that all they have done is obtained an addition to their lease for the duration of the lease. So the answer is that anything that they obtain under the doctrine of accretion cannot outlast the term of their original lease. It's just presumed to be added to it, and the landlord is stopped from denying that. So that is the answer to that. And again, the judgment in McGee and long-term reversions, Harrogate Limited in the first-tier tribunal, deals with that point. So I think, does that address more or less all the questions that are on there?
It does. Yeah. So there's no open questions.
Okay, unless anyone has a short opportunity to ask any further question in the Q&A box, otherwise I think you've heard enough from us on this fascinating topic. We can end where we started with Fortinbras and his army, and you can know to reel out those quotations from the judgments by way of warning any client before they embark upon a very costly boundary dispute. Someone has said, very last point, aside from not asking for comment on where a boundary is, what would you suggest we ask an expert? Draw a plan. Draw what you see. That's it. That is the limit of the expert's role. Possibly if there are aerial photographs and you've got someone who's specialist in analysing those, you might want to ask them some questions about what they show on the land and to try to plot from an aerial photograph onto a CAD plan. That can sometimes be useful. But again, it just depends on the case, and it depends what's in issue, and it depends on what the original conveyance says. If the conveyance says all that land up to a wall shown on the points A, B on the attached plan, and that wall doesn't exist anymore, you will want to ask the surveyor to go and have a look to see if he can see any evidence of, for instance, the foundations of that wall, and you'll want him to write a report describing what he saw and mapping that on a plan. But again, it's very case sensitive. Just never ask a surveyor to give an opinion on where a boundary is. The most common misconception in boundary disputes. It must stop, as Harley's judgment in the case that I can't remember the name of now makes very clear. And I think Harley said to me earlier that that judgment has now been widely quoted in Ruoff and Roper on registered conveyancing. So if you're struggling to find it on the first-tier tribunal's website, you can find it quoted in Ruoff and Roper. Surveyors, stay within the boundaries. So I think then that's all from us. So I'll ask Jasmine to end the webinar, and any other questions, instruct us.
Thanks, everyone.